This week on the podcast, if the client wants to change the date of the wedding, are you allowed to charge a rescheduling fee? Stick around and find out.
This is the Wedding Industry Law Podcast, a podcast dedicated to wedding professionals that are just trying to keep it legal. And now, your host, Rob Shank.
Hey out there, welcome back to the podcast. Today we're going to be talking about whether or not you as the wedding professional are allowed to charge a rescheduling or a rebooking fee when the client has told you that they want to move the date or postpone until another date. So before we get into that though, I am begging you, please, if you are enjoying the content of these episodes, please let me know somehow. Send me an email. Say hi to me at the drive-thru of Taco Bell, smoke signals, whatever the case may be. Let me know if there's something that you want to hear about. If there's a topic that is interesting to you that you want me to address, I will do it on a future episode. But also check us out on YouTube. There's lots of videos over there, not just this podcast, but videos dealing with other aspects of running a wedding business. So check us out there, Wedding Industry Law on YouTube. And with that, let's get into the content of the episode. So you're in a situation in which the client, you've entered into the contract with the client, you've been doing work with that client, and the client comes to you and says, I want to change from date A to date B sometime in the future. Are you allowed to charge a additional fee, whether you're calling it an administrative fee, rescheduling fee, rebooking fee, whatever you want to call the thing? Can you do that? The short answer is yes, you can, as long as it's in your contract. And we'll address this situation if it's not in your contract at the end of the show. But if typically you can do almost anything you want with a contract. You can, what was it, Rumpelstiltskin? You can have the firstborn named after you if you want to, depending on what happens with the contract. I'm just kidding. That is not the case. You can't contract for illegal things, okay? Maybe baby naming, maybe not illegal. Anyway, I guess the point I'm trying to make is you can contract pretty much anything you want to. So rescheduling or rebooking fees are not something that you're disallowed from doing. You can do that with the language of your contract. So in this situation, when the client wants to reschedule, if it's in your contract and it says you owe me this much if we do that, perfectly acceptable. So I do want to throw 3 or 4 considerations at you with regard to how you go about making the client pay you more if they want to change the date. All right, so some considerations for your rebooking fee in your contract. The first one is it's typically going to be a good idea to address why there is an additional fee. Now, some of you have it where it's like, okay, well, I was expecting this date or that date, and maybe I would forego business opportunities on this date. Now you've changed it, blah, blah, blah. That's good. But also address maybe it's a seasonal change if you're offering a product like flowers or something. So a flower might be more expensive if you move it to November than if it's in May. If you can address the why of why there is a charge to begin with, aside from I just hold these dates, that's going to be very important. And another example would be seasonal dates that are more expensive. There are premium dates. So the premium, and you know what the premium dates are in your region. So you might explain to the client in the contract, particular times of year are more expensive. And so moving your date to that time of year when we originally agreed to the less premium times, that's an explanation as to why there is a charge in the first place. So that first consideration is give a little bit of consideration, give a little bit of wording to why there is a rescheduling or rebooking fee. The second part is, or the second consideration is to address along those same lines specificity as much as possible about why the amount is being charged. So sometimes I have clients that come to me with their contracts that say, well, I just charge a flat $1,000 fee for rescheduling. Or I charge a flat $200 fee, or whatever the case may be. My recommendation is to, as much as you can, attach the amount, if there is an amount, if you're going to specify an amount, attach that to the why. So, for example, if you're saying that there is a season, if you're going to a premium date, you're specifying that the recharge fee is then $500 because that represents the difference between your date and this new date if you go into those premium dates. Or it's a $300 upcharge because this product at this time of year is more expensive, and you're specifying an amount to the extent that you can, although I understand that that's not always possible. But when you try to address the why and you try to be as specific as to the amount as you can, then you are helping yourself educate the client, and then later on possibly educating the judge, which it's a good segue into the third consideration, which is I don't think that you should pull an amount off the top of your head. Have a basis for it. And the reason why is because I've dealt with clients where their rebooking fee, it's like, well, I got to keep my lights on, I've got to pay rent and things like that. Well, those type of charges should already be baked into the cake of your price. They should already be baked in the cake of your price. So when you're arbitrary in your amount, I'm not saying that's wrong. I'm just saying if you're arbitrary in your amount, if you just pick an amount out of thin air, then your client has more of an ability to fight you on it on a business customer relation level. And there's a possibility that down the road, a judge might fight you on it in terms of what is reasonable, or potentially what state you're in, what is unconscionable, meaning not enforceable because it's not fair, in such a way that the judge might say this is some type of penalty that is preventing the client from rescheduling or whatever. We don't want to go down that rabbit hole. But the more information you provide, the less you're pulling it and you're making it arbitrary, the more likely it is to be enforceable. I'm not saying that if you don't do any of these things, it won't be enforceable. I'm not saying that at all. I'm just saying these are considerations that are going to help you if there is a lot of pushback or from the client, or there's legal pushback, meaning that there's an attorney or a judge that's reading this thing. So the last consideration that I would tell you, that I would recommend, is to make sure that somehow in your contract, this rebooking fee, this rescheduling fee, applies to situations that are not just the client's doing, that the client's like, well, I just want to change the date because now we want to have a November wedding, or now Aunt Millie can come and she can only come in October or whatever. The reasons that the client wants to reschedule is within their control. That's obviously address the rescheduling fees in that situation, but you also want to connect that as well to situations that are beyond the party's control. And we are talking about force majeure situations. So you want to make sure that whatever rescheduling fee you have, you want to make sure the contract says that it applies to situations within the client's control, and then, of course, with force majeure situations. It's crucial that you understand that that the rabbit hole that you go in when there's a force majeure event is a different rabbit hole from when the client wants to change the contract for reasons that are within their control. So make sure that the rescheduling fee applies to both situations if you can. Now, Rob, what about the client wants to reschedule and my contract does not address rescheduling? What happens then? Can I charge a fee then? So again, depending on the wording of your contract, the other portions of your contract, because a judge is going to read the whole thing when deciding what law applies or how they're going to enforce this contract. So if assuming that you have no language in your contract about whether or not the client can reschedule, and some of you do or do not have that. So if your contract is just, I'm going to show up on date A and provide you services with really nothing else about rescheduling or rebooking or postponing or anything like that, then what has happened, more than likely under the law, is the client is coming to you and going, can we amend this contract? Can we change the date, a key term in this contract? And you're free to say yes or no. Okay, again, assuming that this is not addressed in your contract. The client is essentially saying, I am wanting to amend this contract with a new date. No one party can unilaterally change a contract or unilaterally amend a contract. So the client essentially is saying, please, will you agree to amend the contract? And you're free to say yes or no. If you're wanting to say no, then that's a whole different category. The contract essentially, or the client is essentially in breach, and you got to, chase that down however you want to. But let's say that you do say yes, okay, that's fine. It doesn't say anything about that in our contract, but you're coming to me, you're wanting to amend the contract by changing the date. I will agree to do that if you agree to pay XYZ more, or you pay this rescheduling fee. And so that's kind of your counteroffer to their offer. So the amendment is kind of like a new contract, in other words. So the client comes to you with their offer, and you can counteroffer with, yes, I'll accept that new date, but you got to pay XYZ more. And then now you have a new contract, a new meeting of the minds. That amendment becomes the new contract that reflects the obligations of the parties moving forward to the new date. Obviously, it is much better to address rescheduling fees and rebooking and allowing the client to change the date of the event in the original contract. So that way there's no issue with like, well, the client's coming to me now and they don't want to pay $1,000 or they don't want to pay $50 or whatever it is for the rescheduling fee. When it's in the original contract, it's sorry, Charlie, right? So get it taken care of as early in the process as you can, and you can't get any earlier than in the original contract. So again, like I said, if you don't have it in your contract and your contract doesn't speak to it at all, then it's just about what the parties are going to be able to agree to. Otherwise, the client has, what I would argue, is anticipatorily breached the contract. But anyway, that's for another episode. I hope that this episode, short and sweet as it was informative for you. If you are enjoying enjoying the content of these episodes, please like and subscribe. Share it with your friends. You've got a best friend. Make sure to be like, hey, do you know who Rob is? Do you ever listen to his podcast? It is meandering at times, but sometimes it's fun to listen to. Anyway, that's going to conclude this episode. New episodes of the Wedding Industry Law Podcast every week. They drop, as the kids say. As the middle-aged people now say, kids, from 20 years ago would say it. It drops every Monday. So be on the lookout. Check us out on YouTube. Check us out wherever you get your podcast from. And with that, we'll see you next week, folks.
Thank you for listening to the Wedding Industry Law Podcast. This podcast is intended for general information only. Nothing in this podcast is intended to be legal advice. Do not rely on this podcast for your legal matter. Instead, consult an attorney in your area. Thanks, obrigada, até semana que vem.